Welcome to this video on supported decision making. In this video, we will be discussing guardianship. The information in this video is provided for educational purposes only and should not be a substitute for actual legal advice by a licensed attorney in your state. This video is part of the Supported Decision Making Pilot Project and is funded through a grant by the Arizona Developmental Disabilities Planning Council. The partners for this pilot project are the Arc of Arizona, Southwest Institute for Families, and the Arizona Center for Disability Law. So what is guardianship? In this video, we will discuss legal definitions and obligations, an individual's rights under guardianship, two modes to attain guardianship, testamentary and petition, candidates for guardians, and steps a petitioner takes in order to become a guardian. So what is the legal process? Guardianship is a legal process where one person petitions the court to oversee the care and decision-making for another person. A person under guardianship is called a ward. A guardian is a person who has qualified for the role of guardian of a minor or incapacitated person, but excludes a person who is merely a guardian ad litem. A guardian can be appointed by will or through petition. The court will look at the person who is subject to guardianship and that person's capacity to determine whether the individual needs a guardian or not. So what is incapacitated? So the Arizona Revised Statutes defines an incapacitated person as someone who is impaired by reason because of mental illness, mental deficiency, mental disorder, physical illness, physical disability, chronic drug use, or someone who lacks sufficient understanding or capacity to make or communicate responsible decisions concerning the person. Many rights are at stake during guardianship. With guardianship, the court is essentially taking away an individual's right to choose for him or herself and granting that decision-making to someone else. A guardian has many duties. Some of these duties are the general health care of the ward, training and education when it's appropriate, clothing, furniture, vehicles, and other personal effects, receiving monies if the ward is entitled, unless a conservator is in place. If appropriate, a guardian shall encourage the ward to develop maximum self-reliance and independence, and shall actively work to limit or terminate the guardianship itself, and seek other alternatives where appropriate, like supported decision-making. A guardian also has the responsibility to find the least restrictive setting for the ward. The guardian shall seek services that are in the best interest of the ward, such as schooling, day programs, and etc. And the guardian shall listen to the particular desires of the individual or the ward. So the guardian should really understand what the ward likes, what the ward dislikes, and tries to work in a way that balances that with the ward's best interest. So here are some individual rights that may be given up if full guardianship is granted. So the right to vote, healthcare decisions, education and training, consent to marriage, and financial decisions. So financial decisions are things like purchasing major electronics, purchasing other items, and things related to one's personal financial decisions. Who can be appointed a guardian? So generally, any person is qualified. Any person who is qualified and can act on the individual best interest can be appointed a guardian. That individual should know the ward or the person who's subject to guardianship, and should be able to articulate what that person's best interests are. And there is a hierarchy, but the court may choose out of a number of people who is actually in a position to advocate for the best interests of that person. But the hierarchy is someone who's already appointed a guardian in the same county, someone nominated by the individual, the ward, a person nominated by the ward's power of attorney, if there is a power of attorney, the ward's spouse, an adult child of the ward, or any other relative of the ward who the ward has lived with for the past 6 months. So, as I mentioned before, there are 2 steps or 2 different ways to becoming a guardian. The first way is testamentary. It's usually done by will. So in this case, a parent by will or other signed writing may appoint a guardian for an unmarried child who the parent believes is incapacitated. The parent can specify desired limitations. So, for example, the parent can say or can appoint by will for the sole purposes of like healthcare decisions. On the other hand, an individual by writing or other signed writing may appoint a guardian for that individual's spouse, who the appointing spouse is believed to be incapacitated. So generally, if it's a parent of an unmarried child or a spouse of someone who is believed to be incapacitated, the individual, the parent or the spouse, may, through testamentary means like a will or other signed document, may appoint a guardian that way. The person having care of custody of the person subject to guardianship, so in this case, a ward, or the adult with the nearest kinship relationship to that person, can file an objection to that appointment. And if there is an objection in place, if there is an objection filed, the court will hear the objection and will make the appropriate assignment of guardianship. The second way a guardian can be appointed is through petition. An interested person may petition the court in the county where the person subject to guardianship resides to be guardian of the incapacitated person. The court will set a hearing, notify all parties, and hear evidence. The individual that is subject to guardianship or anyone interested in the welfare of the individual may object, at which point the court will schedule a hearing to hear the objections. The individual who is subject to guardianship has a right to appear in person, to be represented by an attorney, to present evidence on his or her own behalf, to cross-examine, and to request a jury trial. So here's some information about supported decision-making generally. For more information, you can visit our website to download the training manual and activity sheets to help you make your own supported decision-making plans. You can also find us on Facebook, where you can keep up on the latest news training, and events. And the links are provided below. And here's some contact information. If you have specific questions, you can contact Southwest Institute and speak to George Garcia, the ARC of Arizona and speak to John Myers, or the Arizona Center for Disability Law and speak to me, Cy In, a staff attorney there.